Welcome to Part 3 presentation about the history of law and medicine in America. I am Dr. Sandbar, a physician and an attorney. In 1804, in the United States, Dr. J.S. Stringham was the first lecturer on legal medicine. He gave his lectures in New York. In 1813, the first chair of medical jurisprudence was established by the College of Physicians and Surgeons of New York City. It was filled by Dr. Stringham. In 1815, the College of Physicians and Surgeons of the Western District of New York appointed Dr. Theodoric Romaine Beck as professor of the Institutes of Medicine and lecturer on medical jurisprudence. Dr. Beck published the Elements of Medical Jurisprudence, which defined the field of legal medicine for about half a century of American medical practice. Beck's 2 volumes include impressive topics such as rape, impotence and sterility, pregnancy and delivery, infanticide and abortion, legitimacy, presumption of survivorship, identity, medical alienation, wounds, poisons, persons found dead, and feigned and disqualifying diseases. In the same year, the medical department of Harvard University appointed Dr. Walter Channing as the professor of midwifery. Channing was awarded an M.D. from the University of Pennsylvania in 1809. He studied in Britain for a year. He served as Dean of Harvard Medical School from 1819 until 1847. He was one of the founding editors of the New England Journal of Medicine and Surgery in 1812 and an early editor of the Boston Medical and Surgical Journal. He published lectures entitled Of the Medical Profession and of its Preparation in 1845 and The Law of Compensations in 1855. Also, in the early 1800s, Dr. Benjamin Rush emphasized the significance of a relationship between law and medicine. He was the nation's first U.S. Surgeon General and a signatory of the Declaration of Independence. Dr. Rush established American legal medicine with his published lecture on the study of medical jurisprudence, which he delivered to medical students at the University of Pennsylvania in Philadelphia in 1811. The lecture dealt with homicide, mental disease, and capital punishment. The works of Dr. Stringham and Dr. Rush inspired the teaching of medical jurisprudence in other American medical schools. Among the early teachers were Dr. Charles Caldwell in Philadelphia and Dr. Walter Channing at Harvard. Dr. Thomas Cooper studied both law and medicine. He was educated at the University College in Oxford. He immigrated to America in 1793. He was a legal officer of distinction, and he became president of the College of South Carolina. In 1819, Dr. Cooper published Tracts on Medical Jurisprudence. This volume contained almost all available literature written in English on legal medicine. In 1838, psychiatrist Isaac Ray was one of the founders of the discipline of forensic psychiatry. He published a treatise on medical jurisprudence of insanity, which served as an authoritative text for many years. In 1843, the treatise was deployed effectively by defense lawyer Sir Alexander Cockburn in the English trial of Daniel Macnaghten. At the trial, Cockburn quoted extensively from the book, which rejected traditional views of the insanity defense, based on the defendant's ability to distinguish right from wrong in favor of a broader approach based on causation. In 1855, which happened to be the year that Dr. Beck died, Francis Wharton, an attorney, and Dr. Morton Stile, a physician, collaborated to publish a treatise on medical jurisprudence. In 1860, Dr. John J. Elwell, who was a physician and an attorney, published a book entitled A Medico-Legal Treatise on Malpractice, Medical Evidence, and Insanity, comprising the elements of medical jurisprudence, which highlighted the issue of malpractice in the medical jurisprudence literature. Elwell's book presented excerpts from contemporary cases for the purpose of teaching physicians what to expect from malpractice litigation. Dr. Odorno, also a physician and an attorney, published Jurisprudence of Medicine in 1867 and Judicial Aspects of Insanity in 1878. In 1894, Randolph A. Whithouse and Tracy C. Becker published Medical Jurisprudence, Forensic Medicine, and Toxicology. For medical students and physicians, medical jurisprudence assumed the position of central importance in U.S. schools of medicine throughout most of the 19th century. The institutions, laws, and judicial decisions in America reflected the increasing influence of sound medico-legal principles, especially those pertaining to mental disease and criminal lunacy. After the Civil War, however, things changed drastically. Legal medicine became temporarily dormant. American professor and Dean Stanford Emerson Chaley expressed his view of the deplorable condition of medical jurisprudence in the United States. Chaley demonstrated how the teaching of medical jurisprudence had deteriorated by noting that in some medical colleges the course had been dropped altogether. In others, it had been attached to some other subject, and in many colleges the teaching of medical students was entrusted to an attorney with no formal training in the medical field. In 1867, the Medical Legal Society was organized in New York. It was the first society in the world to be organized for the purpose of promoting two important principles. First, that an attorney could not be fully equipped for the prosecution or the defense of an individual indicted for homicide without some knowledge of anatomy and pathology. And secondly, that no physician or surgeon could be a satisfactory expert witness without some knowledge of the law. 10 years later, in 1877, Harvard University established a separate professorship in legal medicine. In the early 20th century, the teaching of medical jurisprudence was relegated to a position as an occasional subject taught outside the mainstream. However, by the middle of the 20th century, legal medicine underwent a renaissance, as evidenced by the establishment of the American College of Legal Medicine, ACLM, the founding of the Law Medicine Institute at Boston University, and the rekindling of contemporary interest in a vast array of legal medicine issues, medical ethics, physician and patient's rights, and business and professional aspects of medical practice. In 1955, a group of physicians and surgeons, some of whom were educated in law, recognized the growing impact of legislation, regulation, and court decisions on patient care and the general effect of litigation and legal medicine on modern society. They organized what would later become the aforementioned American College of Legal Medicine, ACLM. In 1960, the college was incorporated by 9 doctors of medicine, 3 of whom were attorneys. 36 physicians were designated as founding fellows, 10 of whom were dual-degreed in medicine and law. The ACLM is the oldest and most prestigious U.S. organization devoted to problems at the interface of medicine and law. Its membership is made up of professionals in medicine, osteopathy, and allied sciences, including dentistry, nursing, pharmacy, podiatry, psychology, and the law. The ACLM has published a scholarly journal, the Journal of Legal Medicine, since 1973. In 1988, the ACLM also published the first edition of the textbook Legal Medicine. The 7th hard copy edition of the same text was published in 2007. The 8th and 9th editions, Legal Medicine and Medical Ethics, were published in 2010 and 2015, respectively, as e-books. In 2007, the ACLM published the Medical Malpractice Survival Handbook. Dr. S. Sandy Sandbar served as the editor of all the ACLM legal medicine books, e-books, and the Medical Malpractice Survival Handbook. In 1911, the Massachusetts Society of Examining Physicians was founded in Boston. In 1968, attorneys were admitted as non-voting members. In 1972, a physician and 2 attorneys founded the American Society of Law and Medicine. Dr. Elliot L. Segal was its president. He co-taught a course with George Annas, an attorney, on law and medicine at Boston College Law School. In 1992, the society was renamed American Society of Law, Medicine, and Ethics. The organization quickly became the largest medical legal organization in the world, dedicated to continuing education, as well as the publisher of the 2 leading medical legal journals, the Journal of Law, Medicine, and Ethics, and the American Journal of Law and Medicine, which is published as a law review at Boston University Law School. From World War II until the late 1960s, the field of legal medicine was defined by law school courses that were almost exclusively concerned with forensic psychiatry and pathology, and they were properly considered as advanced courses in criminal law. In the late 1960s, some law and medicine courses began concentrating on broader medical legal questions faced in the courtroom, including disability evaluation and medical malpractice. These courses were properly considered either advanced tort or trial practice courses. In the 1970s, the concerns of at least some law and medicine courses expanded to include public policy, including access to health care and the quality of that care. At the same time, advances in medical technology created new legal areas to explore, from brain death and organ donation to abortion and in vitro fertilization. These topics were increasingly incorporated into law and medicine courses, which were themselves becoming known by the broader term of health law. Teachers of health law in law schools and medical schools, together with health law teachers in schools of public health and schools of management, began meeting on a regular basis in 1976, when the first National Health Law Teachers Meeting took place at Boston University under the auspices of the law school's Center of Law and Health Sciences, the successor organization to the Law Medicine Institute. The purpose was to help define expanding field and develop necessary teaching materials. In 1987, the American Association of Law Schools sponsored its first teaching workshop on health law. Its program and proceedings offered useful insight into the state of health law in law schools. As the organizers of the workshop saw it, law and medicine, fields primarily concerned with medical malpractice, forensic medicine, and psychiatric commitment, had become subdivisions of the new field of health law. Health law itself has 3 additional subdivisions: economics of healthcare delivery, public policy, and healthcare regulation and bioethics. These 3 subdivisions are actually 3 different approaches to the same subject matter, the healthcare industry. Health law is applied law, much the way medical ethics is applied ethics. In an effort to bridge the gap between law and medicine, some attorneys enroll in medical school or in a dual degree MD-JD program. The number of medical school courses extraneous to a legal practice specializing in medicine also discourages attorneys from pursuing a formal medical education. In 1985, Eugene Schneller and Terry Weiner published their findings regarding individuals who earned MD-JD dual degrees and noted that cross-professional education in law and medicine remains a relatively rare phenomenon in the United States. They concluded that, and I quote, "A combined MD-JD program is probably not the most effective way to teach medical concepts to law students, and it is doubtful that many students are willing to pursue such a long period of training. Moreover, there is more than enough to learn in either field." In 1993, Harry Jonas, Sylvia Etzel, and Barbara Barzanski noted that students can earn combined Doctor of Medicine and Doctor of Jurisprudence, that's MD-JD degrees, in only 9 of 125 degree-granting U.S. medical schools fully accredited by the Liaison Committee on Medical Education, LCME. In 2009, there were 23 such programs and few DOJD combined programs. In contrast, students can earn combined Doctor of Medicine and Doctor of Philosophy, that's an MD-PhD degrees, in 113 of the 125 U.S. medical schools. Most individuals who currently have MD-JD degrees, however, earned their doctorate degrees separately, with most of them earning the MD first. These reasons probably explain the increasingly popular movement toward providing a health law concentration in many law schools and offering joint JD MPH degree programs such as at Boston University and Georgetown University for students interested in health law. Practicing attorneys need a working knowledge of healthcare industry, but do not need to know most of the material taught in medical schools. A well-developed health law program designed to fit into the law school curriculum can prepare an attorney to handle medical matters competently. Existing programs, such as health law concentrations at Boston University, Georgetown, Case Western, St. Louis University, and Loyola of Chicago, are still few in numbers. The American Board of Legal Medicine, Inc., is a nonprofit organization incorporated in 1951 in the state of Delaware. In 1980, the American Board of Law in Medicine, Inc., also was incorporated in the state of Delaware. To facilitate the recognition of legal medicine as a specialty, the two entities merged in 1987, with the surviving entity being the American Board of Legal Medicine, Inc. In 1982, the American Board of Legal Medicine began to administer examinations to individuals with both legal and medical degrees. By 2019, the ABLM has certified over 300 MD-JDs in legal medicine. Other specialty groups that may have some relevance to MD-JDs are the American College of Physician Executives and the American College of Quality Assurance. The teaching of medical legal problems in American medical schools has not, however, been as swift or as comprehensive as one would desire. Although many respected authorities in the field have urged for a long time that the active teaching of forensic medicine should be a responsibility and duty of our medical schools to their medical students, most medical schools have been slow in paying heed to this advice. American medical schools should train students about the medical legal aspects of medical practice. The output of literature on medical legal subjects has increased year by year, and in general, forensic medicine in America and physicians and attorneys are increasingly satisfied with the level of understanding, acceptance, and utilization of this extremely important field of study, legal medicine. Thank you for watching Part 3 of the History of Law and Medicine in America. Be sure to watch Parts 1 and 2 if you have not already done so. Thank you again.